Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, sometimes there's these big issues that come out, like the case we're going to be talking about today. I don't get a chance to jump on it right away because I got this little thing called the law practice, and so I actually get to it several days later. But sometimes, that extra time allows a little additional clarity, allows me to do a little bit more research, and also allows the emotions to subside so we can perhaps give you a little bit more objective information. And what we try to do here at Washington Gun Law a lot is just give you all the stuff to think about, okay? We're not going to tell you how to think. You're all big boys and big girls. You can think for yourself, but we do want to give you all the stuff to think about. Today, what we're going to be talking about is a ruling that deals with ATF's rules on frames and receivers. Now, everything was going really, really wonderfully, and then all of a sudden it seemed like we got this gut punch. Is it really a gut punch? Are we screwed or aren't we? So today, let's spend a few minutes, let's get real here for a second, and let's talk about, did the Supreme Court just save ATF's rule on frames and receivers? Okay, so the case we're talking about yet again today is Vanderstok v. Garland. We know a lot about Vanderstok v. Garland. We know this is a challenge to Rule 2021R-05F, better known as ATF's rule on frames and receivers, where the ATF got this crazy idea that even though Congress had delegated them the authority to regulate firearms, that the ATF could also go out and regulate chunks of aluminum. Did not know that they could do that. Well, actually, the Fifth Circuit agrees with us and said, no, actually, you can't do that. That is well outside the scope of your statutory authority. You have no right to be doing that whatsoever. If Congress wants to have you regulate that, they can go ahead and pass some laws. That basically threw this rule out on its ass. The remedy was one of vacatur, which basically means we're done, rule doesn't exist. Of course, the United States government completely crapped its pants and immediately filed for an appeal to the United States Supreme Court. Now, along with applying for that appeal, one of the other things they did was they asked for a stay of the remedy that had come out of the Fifth Circuit. So, I'm going to try to connect the dots so you can understand that. Essentially, the Fifth Circuit killed the rule on frames and receivers. What the United States government wants the Supreme Court to do is to revive it, to put it on life support, to get it a heartbeat again, and allow it to remain in effect until the appeal is perfected before the United States Supreme Court. Now, that was given to Justice Alito, okay? And rather than getting a ruling, if you want to learn about what happens, you're going to actually have to go to the Supreme Court docket. Looks just a little like this. And right down here is the ruling that we're going to be discussing. The court has granted the United States government request for a stay of that remedy of vacatur, which means that as of the recording of this video, while you're watching this video, this rule on frames and receivers is back in effect. How that affects you in your state, for example, here in Washington State, the ATF rule on frames and receivers doesn't have a lot of effect on us at all because our state screwed us out of that years ago. Many of you may also reside in states that actually operate that way. Some of you, however, still live in the United States of America, and so this regulation being back in existence can, in fact, and will, in fact, change your buying habits. Now, the court's lone docket entry on this reads as follows. Application for stay presented to Justice Alito and by him referred to the court is granted. The June 30th, 2023 order and July 5th, 2023 judgment of the United States District Court for the Northern District of Texas, insofar as they vacate the final rule of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, are stayed pending the disposition of the appeal in the United States Court of Appeal for the Fifth Circuit and disposition of a petition for writ of certiorari if such writ is timely sought. Should certiorari be denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. I know you're all asking yourselves, what the hell does that mean? What it means is the rule is back in effect for now and will remain in effect until the appeal is perfected. However, if the court, the Supreme Court, denies certiorari, fancy way of saying we're not going to take this rule, we're not going to take this case and we're just simply not going to hear it at all, then that is going to terminate the stay. If in fact the United States Supreme Court does accept review, no, you can plan on this rule remaining in effect pending the appeal. Now, here's the last little docket entry, and this is what we also need to talk about, because we find the 4 justices who would not have voted for the stay, which means there were 5 justices that did. Now, the docket tells us which 4 dissented to it, and they are as follows. Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh would deny the application for stay, which means there are at least 2 justices that are supposedly conservative-leaning, conservative appointees that actually voted in favor of the stay. That, of course, would be Chief Justice John Roberts, who candidly is not really a conservative justice. I view him much more as a moderate justice. But also Justice Amy Coney Barrett, which comes as a bit of a surprise, especially when you take a look at her very strong language and her concurring opinion in the Bruin opinion. So, what's going on here? I'm not really sure. Should we read into this more than what has happened here? My answer to that is no, I don't think you should. I think that when we take a look at not only how the Fifth Circuit has ruled, but how the United States Supreme Court has ruled in reining in administrative agencies, clearly going after and pulling these administrative agencies that have completely rung amok, completely become the 4th branch of government, that this Supreme Court has shown an absolute willingness, almost an eagerness to rein them in at any possible time. So either the Fifth Circuit's ruling is going to stand here and this rule is dead, or it's going to get to the United States Supreme Court, and I believe they will kill it. Now, does that mean in the meantime some of us may have to suffer and endure this rule? Unfortunately, that is the case, and that is part of the strategy of those who are advancing civilian disarmament. Do I think that the Supreme Court has suddenly revived this rule to the point where it's going to persist and we're going to have to live with this in eternity? No, I do not. I ultimately think that this rule is a dead rule walking. The case, once again, is Vanderstok v. Garland. We will link it all up down below so you can geek out on it for yourself. If you have any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.